Sentence of the court is as follows: $68 state minimum fee, $130 crime victim's right claims fee, no court cost, no attorney fee, no fine, no supervision fee because there's not going to be probation, and the court sentences the defendant within the guidelines to 23 to 120 months, and I give him 129 days of credit. Now, that might seem harsh. First of all, I think for everything I've already discussed, it's a reasonable and proportionate sentence. Thank you. Also here this morning is Mr. Charles Kennard from the Michigan Department of Corrections, standing in for Ms. Lindsay Simmons, who prepared today's pre-sentence investigation report. Mr. Parrish, yep, you may take a seat. Mr. Parrish is currently in pretrial custody. He's been brought here into the courtroom. We're here today for a sentencing on possession of a controlled substance, methamphetamine. The plea was taken back on March 6th. I have the PSI. Let me see if I have any corrections. All right, Miss Simmons, so far, she did a pretty good job. Let's turn it over and see what the attorneys say. Miss Carey, any amendments, corrections, or objections to make to the contents of the PSI?
I don't believe so. Thank you.
Mr. Harrison.
I have no corrections to the mechanic corrections to it.
All right, allocution then, Mr. Harrison.
I would, again, start out by saying I've had the opportunity to interact with Mr. Perry quite a bit, but I think the point he was making is a valid one, that he is getting too old for this fill in the blank stuff while not on the drug. I think it's a familiar story. We've heard other people express, but I thought he had a rather unique perspective on that because he was willing to say, look, I've done, and we went through his criminal history. Yeah, I've done a number of dumb things in my life, and just about all of them had something to do with drugs or alcohol. So he also inquired of me about, can the judge send me to rehab? Because I think that's something I could benefit from, or something I want to do, or how I want to spend my time. The reason I'm putting that out to you, judges, no, of course you can't sentence him to go to rehab. But the fact that he's even thinking in that direction, as a backup, he's told me he's never going to touch drugs or alcohol again. He wanted to go to rehab as to have a backup of that determination, which frankly I'm pretty impressed with, given his overall, not only his criminal history, but his history as well. We can determine by the number of entries that Mr. Parrish is no saint. Mr. Parrish has not lived a life on the correct side of the law always. And quite frankly, I don't know if that is as much a problem as the magnitude of the offenses that seem to be amplified by his ingestion of controlled substances. I think he's intentional. I think he's got the wherewithal, and I think he's being truthful when he identifies that as sort of being the root of the problem, at least of late, and the fact that he wants to devote some of his time to dealing with that issue. I think, at least they say to me, this is a person who understands where he fits in the continuum of society, as we call it, okay? And he knows that the current position he finds himself in is not tenable. He can't continue to live like this. He's either going to die or go to prison. So we get this PSI. We got a plea we like. We took it pretty well without too much discussion, frankly, between Rob and myself. He kind of looked at me and said, I think that's fair, and I agree. You know, my usual beef with this sort of recommendation is I don't want Mr. Kennard to take this, that I'm taking a shot at him or Ms. Simmons, or maybe I am taking a shot at the departmental policy, but from my perspective, it's not helpful to give us, hey, put him in jail, judge, and he's been there 129 days, good luck, that sort of thing. My inclination on a 5 to 23 guideline would be, hey, judge, let's stick to the low end of that guideline because despite everything that I've just told you about his extensive criminal history, he's not even maxed out on PRVs. He's 5 to 23. That's an attractive way, I guess, to say, hey, if you want to stay within the guidelines, if that's a concern to the court, then 5 months is an appropriate sanction under that guideline. Realistically speaking, I don't know if the court's willing to go that low, but as you can see, the recommendation is for straight jail as well. So he won't have the benefit, if you will, of being given the privilege of serving time that would otherwise be encompassed by incarceration under supervision. That's really what probation is. As proposed, they would not have him be on probation. Now, obviously, it's easy to look at that and say, well, gee whiz, Judge, they just want to get rid of him. They don't want to invest any more effort into him. And that's all there is to it. It's not a positive thing. We know why they don't want him under supervision, because his track record on supervision has been deplorable. The only reason I'm willing to be that blunt with the court is that's what he told me. Did you say deplorable? I can't remember. It was words to that effect. So again, I keep coming back to this point. This is a gentleman who understands his situation very well and has the wherewithal and the maturity to say, yeah, here's where I am. I don't want to be there anymore. And I'm not looking back. I'm going to move forward with this when my obligation to Wexford County and the state of Michigan has ended with regard to this case. I don't know that there's any further point to be made here, and I may very well already be beating the dead horse. All I'm saying is drugs and alcohol have not done him any favors. In fact, they've made his life rather complicated, as you can see. Once those factors are eliminated, is he going to be perfect? Well, no, probably not. But he knows now that that's the only way he's got a shot at avoiding another significant prison sentence. Thank you.
Ms. Carey?
I am going to ask the court for a straight period of incarceration, and frankly, I'm leaning towards a prison sentence. He has done so poorly in the past on bond and on probation. It's remarkable. He has 31 entries on his criminal history. The one before this was in 2020, but it took until 2024 to get completed because he absconded in Osceola County. He doesn't do what he's told. He is not a good candidate for supervision. He has been to rehab in the past, according to the PSI, more than once. He doesn't need the court to order it. He can do that on his own. Just since 1992 has been a continual problem. Not following the law, breaking the law, well on bond, not doing well on probation, having periods of incarceration, and yet continuing the behaviors. So I am, again, asking for a prison term. Thank you.
All right, Mr. Parrish, you have the right to make a statement before I issue a sentence. Is there anything you wish to say this morning, sir?
No, I think my lawyer pretty much covered everything, Your Honor.
All right. All right, so here we go. First of all, let's talk. There's a lot to mention here. Mr. Parrish, you had a long history of drugs, alcohol, and marijuana, and they have done absolutely nothing good for you and have put you in a very, very bad position. Now, Mr. Harrison talked a little bit about how your your offense variables, geez, I keep messing it up. Your guideline minimum range is lower than what you would expect. That's because the guidelines are inadequate because they do not count all your non-scorables, and you max out PRV 5 at 20 points because you would have 7 or more. So you have 34 misdemeanors. Wow. On top of that, you've got 7 felonies. The guidelines are inadequate because they do not score your entire criminal history well. And yes, it is correct to say that you have done poorly on bond and probation. Your criminal history as an adult began in 1992. There are 32 entries. There might be a couple dismissals, and I'll talk about them as I go through them. Between entry number 1 and entry number 2, which entry number 2 you picked up while you're on bond for history entry number 1, you made it 4 weeks on bond. Now, one of your number 1 crimes is driving while you're light.
This intense courtroom hearing reaches a powerful turning point as the judge delivers a deeply personal and unforgettable message to a repeat offender trapped in a decades-long cycle of addiction, arrests, and broken opportunities. What begins as a sentencing hearing evolves into a gripping confrontation about accountability, consequences, and survival itself. As the defendant's extensive criminal history is laid bare, the judge reflects on years of failed interventions, repeated probation violations, and the devastating toll substance abuse has taken on his life. Every moment builds tension as the court wrestles with whether punishment, treatment, or tough love can finally break the cycle. What makes this courtroom scene so compelling is the emotional weight behind the judge's words. Rather than issuing a routine sentence, the judge delivers a sobering warning that this prison term may be the defendant's final chance to save his own life. The courtroom becomes charged with raw honesty as the judge speaks directly about the fatal road addiction can lead to, making this far more than an ordinary sentencing. It becomes a dramatic life lesson unfolding in real time. With hard truths, powerful judicial remarks, and a sentence meant to protect both the defendant and the public, this hearing captures the intensity, emotion, and reality that make courtroom drama impossible to look away from.
License is suspended, denied, or revoked. This one, I counted, got counting at 15. You don't lie, you don't comply with the law. You'll do what you want when you think you can get away with it. So, between entry number 2 and number 3, you were still on bond when you picked up your 3rd conviction. By the way, for the same offense you'd already been charged with and convicted of before. Number 4 of 3 also occurred while on bond. Sure enough, it's exactly the same charge, your drivable license suspended, which demonstrates an act of dishonesty to this court. Number 5 of 31, bam, same offense again. By the way, I'm not doing a very good job here of counting this. Beginning on entry 5 of 31, begins your list of probation violations. One of them is going to be interesting. We're going to talk about it. But one of them, again, was while he was in absconder status for a long time. Number 6 occurred while on bond. Yet again, the same offense. And number 7 of 31 while on bond. And it's the same offense. 8 of 31 while on bond. The same offense. Number 9 of 31 while on probation. And it's the same offense. Number 10 of 31 while on probation, and it was the same offense. Number 11 of 31 occurred while on probation, and now it becomes a drinking and driving, and you violated probation, and probation was revoked because you picked up another charge, 12 of 31 while on probation. And again, it was the same offense as before, drivable license suspended repetitively. 13 of 31 occurred while on probation, and it too was the same offense. 14 of 31 occurred while on probation, and it was your 2nd drinking and driving. And that one ended in an auto accident where you fell asleep at the wheel, broke your neck. Like you didn't kill somebody. 15 of 31 occurred while on bond. You were actually on bond for your last drinking and driving, and sure enough, you picked up your 3rd drinking and driving. 16 of 31, now we're up to 2003. Number 11 for drivable license suspended. 17 of 31 occurred in 2004. And failed to pay child support. And on this one, you had, looks like at least 6 probation violations. Again, including drivable license suspended, you had alcohol, marijuana use, failing to attend treatment and rehab. You had rehab. You didn't attend it back in 2006. All right, so now we jump to 2005. That one says it's pending still in Manatee, M-A-N-A-T-E-E, in Florida. All right. 19 of 31 occurred while on probation, drinking and driving. Number 4. And I wrote down here, I've lost count of your drivable license suspended, but I can make a finding of fact clearly that you were driving a license suspended because of your prior alcohol conviction history and how close they are together. 20 of 31 occurred while on probation, marijuana. 21 of 31 occurred while on probation, more of the same, marijuana. 22 of 31 occurred while in 2008 while on probation for drinking and driving, and sure enough, you've got drinking and driving number 5, and there you went to prison, and looks like you had parole violations because you kept testing positive for marijuana after you were released. 23 of 31 occurred while on parole in 2009. More drivable license suspended. 2011, more drivable license suspended. Boy, Osceola County was really nice to you. 2013, while on district court probation. Now here, you had your 6th drinking and driving. And this one, you had 11 probation violations. It took until your 6th one before the Osceola County gave you a prison sentence on your 6th drinking and driving. 2013, while on probation, more of the same. Driving license suspended, meaning you're going to put people at risk. 27 of 31 in 2014, violated probation by committing more of the same offense. Number 28 of 31, again, on probation, committed the same offense. Whew. 29 of 31 in 2020, resist obstructive police officer. You got some probation. Sure enough, you absconded and violated probation. 30 of 31 is a possession of methamphetamine, for which we are here today on. And you also have another charge pending down in Osceola County. Interestingly, the offense date here today was July 22. So after getting caught driving a vehicle, having methamphetamine, being a habitual offender 4th, and getting charged or cited with another drinking and driving, which has got to be somewhere in the 20s by now, before they could charge you here, you were driving a car 4 days later and got caught in Reed City. It's like, wow, it looks like that has been resolved. So that tells me that, Mr. Parrish, you are not putting any real effort into changing your lifestyle. Now, Mr. Harrison nailed it on the head. Well, you are either going to die or go to heaven, or prison, sorry. Maybe heaven, I hope so. But anyways, here's the point. Oddly enough, we all get a lot of pressure as judges. Judges, we're not going to give you any more community correction money if you send people to prison on straddle cells. By the way, we're not going to actually give you any money to do any much more rehabilitation. We're not going to help you build a rehabilitation program. We are not going to give you dedicated beds, but we're not going to give you money to even do your pretrial monitoring if you keep sending people to prison. I do not care. I do care, but if they don't want to make sense and give us the money, that's up to them. But you deserve a prison sentence, because if I don't give it to you, you are going to die. Kill somebody. Now, the next comment, I don't mean it to be rude. I mean it to be about your health. You look like you're older than all the attorneys and me here, but you're younger than all of us because you are living a hard life. These drugs, this alcohol, it's killing you. You don't seem to control it. And nothing anybody does stops you. It's really unfortunate. I bet you got a lot to give people. I think everybody's got good things to give people. Sentence of the court is as follows. $68 state minimum fee, $130 crime victims' right claim fee, no court cost, no attorney fee, no fine, no supervision fee, because there's not going to be probation. And the court sentences the defendant within the guidelines to 23 to 120 months, and I give them 129 days of credit. Now, that might seem harsh. First of all, I think for everything I've already discussed, it's a reasonable and proportionate sentence. And I also think it's reasonable because you've got to get the message. And I don't think the other judges have sent it to you, but I'm going to send it. I'm going to separate you from your lifestyle for almost the next 2 years. I really hope that you pick up some skilled trades. I hope that you take advantage of the rehabilitation programming. You're not eligible for boot camp because you've already had that and that didn't work. I really hope for the best, Mr. Parrish, because everything that everybody's done for you, and maybe the pressures from Lansing about what we're supposed to do, is just not working. I'm really sorry to see that. Mr. Harris is going to bring you 2 copies of one document. You're going to place your initials on one copy. Doing so neither elects nor waives any rights. It merely acknowledges your receipt of your copy of that document. Now, this document tells you that you have the right to appeal the conviction and sentence in your case. That is typically done by filing a claim or right to appeal. However, based upon the plea in this case, any appeal must be done by filing an application. If you choose to file an application for leave to appeal and you want the court to appoint an attorney to assist you, you may complete the bottom half of that document and return to the court within 42 days. If you choose not to appeal, you may simply dispose of your copy of the document. Mr. Parrish, let's hope today isn't taken by you as this judge being rude, but I hope that you take it as this judge is trying to encourage you. Change your life now. If you don't, you will end up dead from drugs and alcohol if you don't kill somebody first.
As the courtroom proceedings reach their conclusion, the atmosphere remains heavy and emotionally charged, with the impact of the judge's final words still echoing through the room. The sentencing marks the end of a long and difficult legal journey shaped by decades of substance abuse, repeated arrests, and countless missed chances for rehabilitation. Despite previous interventions and opportunities for treatment, the defendant once again finds himself facing the consequences of a cycle that has followed him since the early 1990s, leaving the court to confront the harsh reality of what continued addiction and non-compliance have led to. In delivering the final sentence of 23 to 120 months in prison, the judge emphasizes that this decision is not made lightly, but out of deep concern for both the defendant's future and public safety. The courtroom becomes silent as the judge issues a final direct message, framing this incarceration as a potential life-saving intervention rather than just punishment. It is a moment filled with gravity, where accountability, consequence, and the hope of change intersect in a powerful way. As the defendant is taken into custody, the weight of the ruling settles over the room, marking the end of one chapter and the uncertain beginning of another. The judge's final warning about the deadly risks of returning to old habits leaves a lasting impression, underscoring the seriousness of the path that has led here. The hearing closes not with celebration or relief, but with a sobering reminder of how fragile second chances can be, and how the next decision outside these walls may determine everything.